Hello and welcome to topic 6, where we are going to be continuing our discussion about criminal law from last week. And in this lecture, we're going to be taking a look at criminal defenses. Okay, so last week you learned about the different elements of the crime: actus reus, mens rea, etc. And you were looking at the criminal justice process through the lens of the prosecutor. That you learned that to get a prosecution, you must prove beyond a reasonable doubt that the accused engaged in or possessed each element of the crime. Okay, so you had to prove mens rea, you had to prove actus reus, etc. That's what we did last week. This week, you're going to be looking at the criminal justice system through the lens of the defense attorney. And that what the defense attorney does is that their goal is to raise doubt on one or more elements of the crime. And so the prosecution actually has a much tougher burden. They have to prove beyond a reasonable doubt all the elements of the crime. But for the defense attorney, all you really need to do is raise doubt about one of the elements of the crime, because in order to convict somebody, you have to prove all of the elements of the crime. Good defense attorneys will oftentimes raise doubt about more than one of the elements of the crime, but one can sometimes be enough. So that's what we're going to be doing this week. So let's go ahead and get started. Okay, so the goal of the criminal defense is to refute one or more elements of the crime. And so one thing that the defense can do is they can deny actus reus. Remember, actus reus is that the person engaged in the criminal act. So what a defense attorney could say is that, yeah, the criminal action did take place, but the person that you accused of the crime, my client, that they didn't engage in that criminal act. In other words, my client is falsely accused. And so that's one approach that criminal defense attorneys can take. They can say, you've got the wrong person. There are lots of examples of people who have been falsely accused of crimes, and oftentimes it's hard to argue the false accusation, because usually prosecutors have pretty sound evidence that they present that the person who's accused of the crime actually did the crime, but not always the case. Central Park 5 is a good example of that, and I'm bringing that up as an example because they're going to be referenced in the documentary that you're watching this week, the 13th. The Central Park 5 is the case about a woman who was jogging through Central Park in the late 1980s. She was assaulted, horribly assaulted and raped, and that 5 African-American and Latino juveniles, younger boys, they were accused of the crime. And that it was due in part because the treatment of the police officials, they had coerced incriminating statements out of these boys, and that they were found guilty and they served between 5 and 15 years, depending on who the individual was. And then in 2002, that somebody confessed to the crime, and then they looked at the DNA evidence, and the DNA evidence indicated that, in fact, the DNA was of this individual who confessed to the crime, and the Central Park 5 were exonerated. So while the defense team did argue that you've got the wrong people, that my clients are false accused, it was not successful, but it is an example of denying actus reus. Another thing that the criminal defense attorney can do is they can say, okay, look, the person who's charged with the crime, my client, they did engage in this act, but they lacked the mens rea, they lacked the criminal intent needed to be found guilty. So you can say, yes, that this person did engage in this actus reus, but they didn't know what they were doing. They didn't understand the consequences of their crime. They didn't possess mens rea, so they cannot be found guilty. And in this lecture, we're going to talk about different defenses that revolve around denying mens rea. You can say that the person did engage in an act, but they were justified in engaging in the act. And so the example before, that the person did engage in the act but lacked mens rea, is what's known as an excuse defense. But the second one is that the person did engage in the act, but they were justified in engaging the act. And those are known as justification defenses. And we're going to talk about those in today's lecture as well. That a final thing that a defense attorney can do is they can refute the harm. Remember that you can, to be found guilty, you have to show that the actions of the criminally accused were resulted in the harm to the victim. And a defense could be that my client acted in this way, but their actions didn't result in any harm, at least not the harm associated with what they're being charged with. A good example of that is from 1997. It's the Louise Woodward case. And in that case, this was a nanny. She was from England, and she was working in the United States, and she was convicted of basically killing the 8-month-old child that she was watching as a nanny, and that she was ultimately convicted of manslaughter. But what the attorneys argued was that the 8-month-old actually had a pre-existing injury. And so what she was accused of doing was getting so angry at the baby that she shook the baby really hard, basically, resulting in a cerebral hemorrhage that killed the 8-month-old. And what the attorneys for Louise Woodward said, and again, they weren't successful, but it's a good example of trying to raise doubt around the harm, is that they said that Louise Woodward did not shake the baby. She was just rocking the baby. He was crying, and she was really trying to calm him down. But that these gentle rocks that she were engaging in actually triggered a pre-existing head trauma that the baby had sustained 3 weeks prior to her becoming, the nanny and taking care of the baby. So basically they said, yeah, she was rocking the baby, but she didn't cause a cerebral hemorrhage. That cerebral hemorrhage was already there in the baby's brain. It wasn't successful, but it's a good example of refuting harm. In this lecture, we're going to look at the two middle ones. We're going to look at excuse defenses, and we're going to look at justification defenses. So let's get started with looking at those two defenses in more detail. Okay, so let's start with excuse defenses. Now, I want you to keep in mind that the purpose of this lecture is to do a broad overview of the excuse and justification defenses. There is a lot more detail in the textbook that you are responsible for reading and using if these kinds of questions appear on the midterm exam. So again, these are just broad overviews, giving you sort of a general basis for what you're going to be learning about in more detail in the textbook. Okay, so the excuse defenses say that the accused should be excused from the criminal action because they lacked the capacity to form sufficient intent to be held responsible, okay? And so, in other words, that they just did not have the capacity, for whatever reason, to understand the consequences of their actions. And so the excuse defenses focus on mens rea, the criminal intent, the criminal mind. And that basically the defense is making an argument that the defendant didn't know that they were committing a crime, or that they didn't have the capacity to understand the consequences of their actions, okay? So let's take a look at some common excuse defenses that are used by criminal defense attorneys. Okay, so the textbook offers 5 excuse defenses, and we're going to talk about 3 of them. We're going to talk about insanity as an excuse defense, age, and intoxication. All of these are excuse defenses. And in the textbook, they also talk about entrapment and duress. And I will leave it to you to read about entrapment and duress. And if you have any questions about those 2 excuse defenses, either drop me an email or come to office hours and we can go over them. So let's get started. Okay, let's start with our first excuse defense, which is insanity. When using this defense, the argument that the defense attorney makes is that the criminally accused should be excused from their actions because they are mentally ill. Now, having mental illness alone is not a defense. That the defense attorney has to demonstrate that the mental illness made it incapable to understand the consequences of the action. So basically, the defense attorney says that my client, because of their mental illness, lacked the capacity to understand the consequences of their action, that they, because of their mental illness, they were not knowingly and willingly engaging in a criminal offense. In other words, that the accused did not possess mens rea. And because they didn't possess mens rea, it negates criminal responsibility. Now, if an individual is found not guilty due to insanity, in Wisconsin, we call it found not guilty due to mental disease or defect, that individual is not set free, usually, okay? If it's the case that the mental illness may have prevented them from possessing mens rea, but that doesn't mean that their mental illness the accused mental illness may still pose a threat to society. And so oftentimes when somebody is found not guilty due to insanity, they're not set free, but they are sentenced to a confinement in a mental institution. And that's because they continue to pose a threat. Going to a mental institution, though, means that you are going to get treatment for your mental illness. And as you get better from your mental illness, the possibility of being released from confinement is more likely. When you're, confined to a penitentiary, the focus is corrections, and that unless the state law has provisions for early release, the chances of getting released early are unlikely in that instance. A good example of excuse defenses are the famous case from the city of Waukesha, which was the Slender Man case that took place in 2014, and I wouldn't be surprised if many of you are familiar with this case. This is a case of two 12-year-olds, Anise Wire and Morgan Geyser, and they were totally into this horror character called Slender Man, and that they were convinced that they needed to kill their friend from school in order to satisfy the demands of Slender Man. If they didn't kill her, then Slender Man would come and kill their family or something like that. So they lured their friend off into the woods, into a park, not the woods, in Waukesha, and then they attempted to stab their friend to death. They were not successful in stabbing the victim to death. The victim survived. However, Anise Wire and Morgan Geyser, they were apprehended, and then they were charged with, in the case of Anise Wire, second-degree attempted homicide. In the case of Morgan Geyser, first-degree attempted homicide. Both of these individuals were found not guilty due to mental disease and defect, and then they were instructed, the court sent them for secure confinement in mental health institutions. Anise Wire for 25 years and Morgan Geyser for 40 years. And just recently, Anise Wire, it hasn't been 25 years, but Anise Wire and her attorney made an argument to the court that she's no longer suffering from mental illness, and therefore it's no longer a threat to the community. And she has, at least as I understand it, as of September, has been released back to the community and is living with her dad. As far as I know, Morgan Geyser is still in secure confinement. Okay, so let's move on to our next excuse defense, which is using age as an excuse defense. Now, when we're talking about age, we're usually talking about children, minors, those who are under the age of 18. And so the question with using age as an excuse defense is the question of, can a child willingly, knowingly engage in a crime? Can the children understand the consequences of their intention? In other words, can children possess mens rea? And the answer to that is, well, it depends on the age of the child. That the older a minor defendant is, the more likely that it is presumed that they are capable of possessing mens rea. In other words, the older the child, the more likely it is that they can willingly and knowingly engage in a crime. Now, the court uses this thing called the presumption of incapacity. And it's basically saying that at certain ages, that children are presumed of being incapable of possessing mens rea. So, for example, any child under the age of 7, so from birth to 6, those individuals are presumed to not have the capacity to understand the consequences of their actions. They're assumed to not have the capacity to willingly and knowingly engage in a crime. They're assumed to not possess mens rea, and so they cannot be held criminally responsible. Between the ages of 7 and 14, the court assumes that they may have the capacity to understand, not that they do have the capacity to understand, and willingly and knowingly engage in a crime, but they may have that capacity, and thus they may be held criminally responsible. Okay, and so in that case, the defense attorney would have to make an argument about why this 12-year-old does have the capacity to understand based on the evidence of the crime. And the defense attorney would say, no, based on the evidence, there's evidence that they really didn't understand the consequences of their actions. Over the age of 14, there's a presumption that they do have the capacity to possess mens rea, that it's presumed that they have the capacity to understand their crime, to knowingly and willingly engage in that crime, and that they should be held criminally responsible. Now, even if they are held criminally responsible, that doesn't mean that they're necessarily going to be tried in adult court. That gets worked out, like whether they're going to be tried as juveniles or adults is going to be worked out as a part of the court process. Now, keep in mind that in each instance, the prosecutors and the prosecution and defense attorneys can challenge the presumption. So just because we presume that a 6-year-old doesn't have the capacity to possess mens rea, maybe the 6-year-old shows evidence of being highly intelligent and highly advanced, and some prosecutor could say, they knew, they willingly and knowingly engaged in a crime. On the flip side of that you could have a 15-year-old where we presume they're capable of possessing mens rea, but the defense attorney could argue to the contrary and say, most 15-year-olds do have that capacity, but not this 15-year-old. And let me enumerate maybe developmental disabilities, or maybe the products of, the mental impact of trauma, etc. So each of these assumptions of capacity can be challenged by both the prosecutor and the defense attorneys. Now, keep in mind that old age would not fall into the presumption of incapacity. So when we're talking about age, we're talking about minors. That there is a presumption of capacity for older people. So I know 90-year-olds and older who are completely have all of their mental faculties. But some older people that don't have all their mental faculties and that they are not capable of possessing mens rea. That wouldn't be argued as an age defense, but rather it would be argued by the insanity or mental disease or defect defense. And so you could say that an old person is incapable of possessing mens rea due to the fact that they have a mental disease or defect, or in this case, a physical disease or defect, and that would be dementia, right? People who have dementia oftentimes don't willingly engage in behaviors, and we know that from reading On the Brain on Trial. Okay, but I just wanted to clarify that when we're talking about age, we're talking about those who are under the age of 18. Okay, so the last excuse defense we're going to take a look at is intoxication. As a rule, intoxication is not considered an allowable excuse defense. The only time that can be presented as an allowable excuse defense is if the intoxication is involuntary, that you didn't choose to become intoxicated. So for example, let's say that you go to a bar and that you order a cranberry juice, and that somebody puts a drug in your cranberry juice that knocks you out, right? And then you might engage in some sort of criminal action, get behind the wheel of a car, kill somebody. But you could say, look, I didn't choose to get drunk. I didn't choose to get intoxicated with drugs. That happened to me without my knowledge, so I should be excused from this criminal offense. And in fact, that would be an appropriate use of the intoxication as an excuse defense. You could also say that you're taking a medication, right? And you're not sure the impact that medication is going to have on your behavior, or maybe it's going to make you drowsy and you just started taking it. Those would be allowable excuse defenses as it relates to intoxication. But for the most part, if you go to a bar and you just start drinking and then you get behind the wheel of the car and you're drunk out of your gourd and you kill somebody, you can't say, well, I was intoxicated. I didn't willingly or knowingly engage in this action. I didn't plan to kill somebody. That would not be an acceptable excuse defense. Intoxication could reduce the charge from first-degree intentional homicide to something lower, manslaughter, but it's not going to excuse you from the crime itself. Well, why is that? I mean, when you are drunk, you're, like I said, you're not willingly or knowingly engaged in an action. You might actually be blacked out, that, you may not understand the consequences of your actions. So in a way, you're really not possessing mens rea at that time. Well, the thinking is that if you are voluntarily intoxicating yourself, well, at the time of being intoxicated, you may not knowingly and willingly engaged in the crime. Prior to the crime, you did know that if you were getting drunk, it may lead to blacking out, and that might lead to some sort of harmful action, a criminal action. And so it's sort of like you should have known better, right? You know that if you get drunk, that you could engage in behaviors that you don't have any control over. And so that's why you are not likely to be excused from your criminal action due to intoxication. Okay, so let's move on to justification defenses. So in a justification defense, the defendant acknowledges that they committed the act, but they claim they can't be prosecuted because they were justified in acting. So in other words, they don't really question actus reus. They said they engaged in this act, but because of some circumstances, they had some right to engage in that act. And because they had a right or a justification for engaging in that act, the act is not a crime. They don't question mens rea. They said, yes, I intended to do this, but they also say that my actions and my intent are justified because anybody in similar circumstances would have done the same thing. So let's look at the different justification defenses that are offered in your textbook. So your textbook offers 4 justification defenses, and we're going to talk about 2 of them. And you're responsible for the other 2. You can just read them on your own. And so the justification defenses are consent, self-defense, necessity, and also the justification that is associated with a professional duty like law enforcement or firefighting. We're going to take a look at consent and self-defense, and I'll let it to you to read the other ones in your textbook. Okay, let's talk about consent as a justification defense. If you're using this defense, you say, look, I'm not guilty of what I've been charged with because I had permission to engage in this act. And because I had permission to engage in this act, that I have not committed a crime. Now, just because you have permission to engage in an act doesn't automatically excuse the defendant. But it can, and it can be an element of the crime that's taken into consideration to mitigate against the accusation of the crime. So for example, let's say cops pull you over because you're driving a vehicle that doesn't belong to you. Well, they might think that you are guilty and should be charged with, or that you've perpetrated auto theft, and that you might be arrested for that. But you could say, yeah, this car isn't mine, but I had the permission of the owner to borrow that car. And so you could go and ask whether the owner gave permission. If they did, then you're justified, that you actually didn't engage in a crime because you had consent. You could say the same thing about sexual consent, that you could say that, you know what, you're accusing me of sexual assault, but I didn't engage in sexual assault because the sexual contact and conduct that I engaged in was consensual conduct. And so if 2 adults consent to engage in sex, that's not a crime. It's only when one of the 2 people did not give their consent. And so oftentimes in sexual assault cases that a defense attorney will say, my client is not guilty because they engaged in consensual sexual conduct, not non-consensual conduct. Now, in some instances, getting consent isn't a defense. So for example, you could say that you had sex with a child, a 14-year-old, and you could say, well, but it was consensual because as an adult, I had sex with a 14-year-old, but the 14-year-old consented to having sex with me. Well, that 14-year-old might have consented to having sex with you, but minors don't have the capacity to offer that consent. Just like they don't have the capacity sometimes to possess mens rea, that a 14-year-old is probably, because of the age difference and doesn't understand sort of, the consequences of the sexual activity, minors cannot give consent. And so that would not be a usable justification defense. If you have sexual contact with somebody who's intoxicated, that you could say, well, they didn't say no, I had sex with them, even though they were drunk. Well, drunk people and drugged up people cannot give consent. And so that's not even giving consent. That's just the absence of consent. But that would not, that you would not be found not guilty because, you said, hey, well, they didn't say no, so I had sex with them. Well, they're drunk, they're stoned, they can't give consent. And if let's say a doctor has sex with a patient, then you could say, well, that also, even though the patient could have given consent, that because the power differential is different, that even if the patient gave consent to have sex with their doctor, they would say that consent is not acceptable because of the power dynamics and the difference. Now, there are some states that criminalize actions even if the consent is fully given. Okay, a good example of that is physician-assisted suicide. So in the case when minors give consent, you say, well, it's not really consent because minors are young, they can't consent to things. If an intoxicated person gave consent, you could say, well, even if they gave consent, they didn't know what they were doing because they were intoxicated. And because of the power dynamic difference between patient and client, you could say, well, that even if a patient gave consent, they weren't able to fully give consent because of the power dynamic. But let's say that you are somebody who's terminally ill and you're well within your faculties and that but you don't have the physical capacity to end your life. Let's say you give a doctor the full and knowledgeable consent that you want the doctor, to end your life. Well, that is consent, but states can criminalize actions even if the consent of somebody is given. So many states have criminalized physician-assisted suicide, just basically saying even if the patient gives consent to end their life, that even with the consent, that law or that action would be criminal and it wouldn't be a usable justification defense. Okay, now let's move on to take a look at self-defense as a justification defense. In self-defense, the claim is that you are not guilty because you were acting in self-defense. That's why it is called self-defense. And so it's a justification because it's like, hey, anybody in my circumstance who felt like their life was in jeopardy, they would have taken actions in order to defend themselves. Now, to claim self-defense, that there are certain things that the defendant needs to prove. The defendant must prove that he acted with reasonable belief that he was in imminent danger of death or harm and that there was no means of escape, like that they tried to retreat and get away and they couldn't, and so then they had to take action. I mean, it's reasonable to make a defendant prove that, because if you just claimed, hey, I shot somebody because of self-defense, well, without having to prove that you really thought that your life was in imminent danger and that you tried to get away but you couldn't get away, well, then everybody would use the self-defense defense, right? Because they'd say, hey, yeah, I felt threatened, but you wouldn't have to actually prove that. So there is a burden that is placed on the defendant that if they want to be found not guilty due to self-defense, they have to demonstrate that they really thought that their life was in harm's way and there was no other alternative for them but to take some action that could harm somebody else. Another thing that the defendant must demonstrate is that the response must be proportional, okay? In other words, that you can only use the force necessary to prevent personal harm, okay? So for example, if somebody's using a deadly weapon against you in some sort of attack, you're being assaulted, you're being, robbed, and they're pointing a gun right at you, you are facing some potential imminent harm if they shoot you with a deadly weapon. And so you could maybe respond, with using your own weapon, right? Because it's proportional, right? That you're using a deadly weapon to counter the use of a deadly weapon on you. It's something that wouldn't be proportional is if somebody, shoved you and was like assaulting you, and then you took out a weapon and you shot them, right? Well, that wouldn't be really proportional. Maybe they're shoving you, you shove back. They punch you, you punch back. But if they shove you and then you, hit them in the head with a bat and kill them, that's not going to be seen as a reasonable response to the harm that was facing you, and it would be less likely that you would be found not guilty due to self-defense. Now, you read in your textbook about that there are exceptions when it comes to self-defense, and they mostly revolve around not only there's the castle doctrine, and then there's also the stand your ground law. And I'll encourage you to read about those in the chapter. In the castle doctrine, it's basically that you can self-defend without retreating. And so that if you're in your home and then somebody enters your home, you don't have to try to escape your home and then, oh, I can't escape my home, so then I can act. The castle doctrine is basically that you can engage in self-defense even without retreating, because it's your home and your home is your castle. Okay, so read more about those two exceptions regarding the self-defense justification to get a fuller picture of it. Okay, so this week you have an extra credit opportunity for 10 extra credit points. And that in Canvas in topic 6, which is the topic for this week, you'll find out more details for this extra credit assignment. This extra credit assignment is designed to give you a chance to sort of like work on an application of these concepts before the midterm exam, because there will be something similar to this, a similar case study, not the same case study, but a similar case study that will be used on the midterm exam. So this is sort of like your chance to work on this case study and then get some feedback from it, and then apply that feedback to your work on the midterm exam. And so for this, you're going to choose one. You're going to, do you want to be a prosecutor or do you want to be the defense attorney? And so if you're the prosecutor, you're thinking of you take the case study and you think about the case study in terms of the elements of the crime. And that in the case study, you have to prove the criminally accused is Mr. Smith, and you have to prove that he's guilty beyond a reasonable doubt of second-degree murder based on the facts of the case. So you have to prove actus reus, mens rea, that the actions that Mr. Smith engaged in resulted in criminal harm. Or you can act as the defense attorney and you can try to defend Mr. Smith's charge of defend against the charge of second-degree murder. You can either use an excuse or justification defenses, and you can using either an excuse or justification defense, you can make a case for why your client is not guilty. You can also raise doubt about actus reus, hey, you've got the wrong guy, or you can raise doubt about harm. And so let's take a look at the case study. Okay, so here's the case study. So the defendant's name is Steve Smith, and he's a veteran of the Iraq War. He served 3 tours of duty over a 4-year period of time. So he had some pretty intense combat experience in a 4-year period of time. He's no longer on active duty, but he suffers from post-traumatic stress syndrome, and he also struggles with substance abuse. So that he's sort of self-medicating with some of the drugs that he's been using. One night he's out with his fellow veterans, and he's involved in a fight with another man whose name is Bob Jones at a bar. And so at the bar, Mr. Smith is out. He's with some fellow veterans. They're just trying to relax. But at the bar, Mr. Jones approaches Mr. Smith, and he just keeps yelling at him. He's calling him names, denigrating his veteran experience and his service in the military. He's basically says a whole lot of horrible things, including, hey, you're a baby-killing soldier. You deserve to die, whatever. I mean, he's really hassling Mr. Smith verbally. Mr. Smith, seeing this situation, left the bar immediately after the fight. He walks to his car. Mr. Jones follows Mr. Smith to his car, continuing taunting him with these angry remarks that are focused on his service in the military. Now, before reaching his car, so Mr. Jones is following Mr. Smith to the car. Before Mr. Smith gets to the car, he turns around in a fit of anger, and he takes a knife out of his pocket and he stabs Mr. Jones, basically trying to prevent him from, continuing to follow him. And that results in Mr. Jones being taken to the emergency room, where he died about 2 days later. Surveillance cameras in the parking lot captured the attack on film. And according to eyewitnesses and medical staff at the ER, that once Mr. Jones was taken to the ER, he kind of sat in the waiting area of the ER, and it took him a while to get that medical attention. Between the stabbing and the death, Mr. Jones was dropped twice while being carried into the ER by fellow patrons. The ER was really close to the bar. So fellow patrons were trying to help Mr. Jones, and as they were, dragging him in there, they dropped him. He was tossed about and before he actually got to the ER. And furthermore, the attending ER physician who was dealing with the series of emergencies, he didn't really realize the serious extent of Mr. Jones' wounds, and Mr. Jones did not receive immediate treatment. He sat in the ER for a while. Despite these factors, the prosecutor charges Mr. Smith with second-degree murder, and that will be defined in the paper that you will see on Canvas. So that's the case study. You act as the prosecutor, and you prove beyond a reasonable doubt the elements of the crime, or you act as the defense attorney defending Mr. Smith and either saying that he has an excuse for an excuse justification, or an excuse defense or a justification defense. You can utilize either or both of those. Okay, have fun, and hopefully, you can earn up to 10 extra credit points for submitting this worksheet.